Here from Houston, Texas, every Tuesday from 5 p.m. Central Time to 6 p.m. Central Time, Reddy Neumann PC does bring in the immigration news update. Emily, what do we have today to discuss?
Yeah, today we want to talk about the big topic of the October 2023 visa bulletin. Is it possible for them to make the filing dates current? Are they considering it? What do we think will happen? How can you prepare for it? What if the dates do become current? Are you ready? What documents do you need to have in order to be ready to file your 485? We also want to talk about a common issue of people who are nearing the 6-year limit on H1B, getting ready to max out. And because the PERM process is taking forever these days, what can you do if the PERM is not approved in time for you to be able to extend beyond that 6-year limit? And lastly, a common question we get is for people who have traveled on the Advance Parole based on their pending 485, but who also have a valid H1B. They decided not being, so they entered the U.S. on their Advance Parole, and they want to know, are they still in H1B? Is it still valid, or are they now using the EAD?
Well, one thing is that we have seen that 56 congressmen have wrote a letter to the administration, to the Secretary of State, and also for the USCI Secretary, saying that why can't you make the priority date current? And I've seen that happen in the Bush administration, where they made everything current in June, July 2007. Of course, you remember the thing what happened at that point of time, Emily. Now, I do think so they can. Now, the question, the billion-dollar question, I wouldn't say $1 million, it's probably million for a lot of people. All you combine, it's $1 billion question is, will they do it? And if they do it, what are the things that our guys need to be prepared for? These are the main things that we're going to discuss in assembly. Of course, you have been there. I mean, in 2007, Emily, when the priority date became current, the State Department made it current, and then they said they are going to take it back. Then they said they are not going to make it. They're not going to allow to file the 485 application after we sent all the packages. And then, of course, then they decided that they will take the application. So they made everything current. All the people whose I-140 approval are there, and where the employer cooperated with them, they did file the 485 application, and they got their EAD and advance parole. You know what happened in 2007. Now the question is, will they do it? Are they considering? Is there any discussion going on in the administration? Is this administration willing to do it?
Yeah, that is definitely the question. And I think what makes this now a little bit different than the 2007 situation is we have two charts. The second chart for the filing dates didn't exist in 2007. That started in 2015. So we only have 7 years worth of history with that chart. And they specifically issued that chart in order to better figure out how many people are in the pipeline and avoid the retrogression and the whiplash of the dates going back and forth, which clearly did not help. And so they could very easily use this dates for filing chart to make the dates current so that anyone with an approved I-140 can file. Now, the date for filing chart is supposed to be a prediction of who will have a green card available to them within the next 12 months. That's what typically has been the idea of a green card being immediately available. It's immediately available if there's going to be one for you in this coming fiscal year, the next 12 months from October 1st. The difficulty with them making the date current for everyone is we know there are way more people in line waiting than green cards available, even for the entire fiscal year. So if we took the entire fiscal year's worth of green cards and made them all available on October 1st to anyone, regardless of priority date, regardless of country of birth, regardless of category, they would receive way more than 140,000 applications, which is the number of green cards we have. So I think that's a bit of a sticking point for me for their wanting to do this. I think it creates some issues for them with the filing fee structure the way it is, because they're going to take in that one filing fee and then have to reissue EADs and APs for decades. And this is really more of a Band-Aid than an actual fix. But it definitely has its positives, you know, helping the age out kids, giving the EAD AP, allowing people to change employers, change jobs, get promoted after 180 days, start a business on the side. Any of those things are possible, which currently they're not possible for someone who doesn't have a 485. I don't know, has there been any discussion among the administration, anyone talking to the State Department? You know, this letter is written by congressmen, and Congress are generally the ones that are in charge of changing the immigration law, but they're saying our hands are tied, there's too much gridlock, there's nothing we can do. So, Mr. President, you tell your State Department, you tell your DHS to make the dates current for us because we can't do this. But has there been any kind of response from the government that you're aware of?
Emily, anything that happens, I'm not aware of anything that's going on inside the government, at least not through the sources that I know, Emily. One thing is that whatever happens, though, mostly it should happen in the month of September. If you recall, Emily, 2015, though, when you are telling that there are two chats, though, the two chats started when? They started in October of 2020, October of 2015, 8 years ago. Now, when they started that, though, in September 9th of 2015, though, they did made an effort to probably move the priority date way more in advance than what it later on turned out to be. So when on September 9th, they published a visa bulletin, though. They did publish a visa bulletin, I think so, if I recall that they made all the way to 2014 current, I mean, very close to the current date, though. I don't recall exactly the date. But then on September 25th of 2015, they took back the visa bulletin, though. Now, obviously, 2015 was Obama period. I don't know why they took it back at that point of time. They could have done it. That's one thing that I see that, well, you know, the Biden administration is a little bit more aggressive in approach, either on immigration or when it comes to the international relationship. He's a little bit nutcase. He can do anything. I've seen, especially when he pulled out the troops from Afghanistan, he was, man, even people were clinging on to the airplane. He still did it. He wants to do it. He will do it. Now, having said that, there are a couple of other things where the administration can do with the executive action, Emily. If you recall, in the Obama administration, before he went out, though, he gave 1 million people who are not documentarily present in this country, though, employment authorization. And those people, even if they have come in undocumented in this country, and if they have stayed undocumented in this country, as long as they have done the high school graduation here in the United States, they entered within the age of 15 years of age, he has given more than 1 million people the employment authorization. Now, of course, that employment authorization, which was given somewhere in 2015 and 2016, is still getting extended right now. I mean, we are 8 years right now, they're still getting extended. So why can't the people who are legally present in the United States, who have an I-140, which the congressmen are asking, whose I-140 is approved, who are paying taxes, whose children probably will age out if the priority date doesn't become current, who are having trouble every time they go outside the country and they come back, they have to get their stamping. They are having trouble because every time they have to deal with the employer, they have to deal with the end clients, they have to deal with the lawyers, they have to deal with a lot of filing fees for the H4 especially, and the EAD, though. So they can avoid all these things by giving the employment authorization. I believe that the administration has the right to give to allow the people to file the 485 application. Now, of course, we can debate about whether or not it's going to happen. We can debate about the legality about it. I want to discuss about if it happens, Emily, what should be done. I'm thinking that, of course, the employer who has the I-140 still needs to give the I-485J supplement based on what my understanding is, especially in 2007, in 2015, and even 2020, when the priority dates moved very aggressively, though. Of course, we need the employer who has an I-140 approval to give the 485J supplement to file the 485 application for these individuals. The things what people are very concerned about is the medical. You can file without medical. You don't have to worry about it. You're good. You can always supplement the medical later on. Birth certificate is one thing that we see a lot of trouble. If you don't have a birth certificate, there are alternatives. You can get 2 affidavits from your friend. You can file it. You can always try to get a non-availability certificate at a later date when the RFE comes in. So in the span, if it's 40 days or 30 days, what I want you guys to work in is that, to have a birth certificate available if you possibly can. Don't work on the medical, because even if they make the filing dates current, the final action dates most probably won't be current. You won't be getting the green card. So I don't see any reason why you have to spend that extra money on the medical. Of course, your employer has to cooperate in filing the 485 application. But anyway, going back to the debate, anything else that you are concerned about?
Yeah, I think, one thing that's different with this potential option versus the DACA program, when they announced DACA, there was no deadline for it. So they weren't requiring people to file those 1 million EAD applications within 1 month, which I think this is kind of what we're expecting, to make the date current just for the month of October. So everyone's going to be scrambling to file in 1 month. Can USCIS handle it? My opinion is that's why we couldn't use the filing date chart when they brought it out in October 2015, because the State Department and USCIS did not coordinate on that. So State Department just puts out the chart, and then USCIS is the one that came out 20 days later and said, oh, no, sorry, that chart's there, but you can't use it. And so I'm afraid USCIS could do that again. Or say, yeah, this chart looks good, but we're not going to let you use it, because they can't operationally handle that number of applications in that time. And the other thing with DACA is, when they file the EAD renewals, they have to pay the $410 filing fee every time, versus when you renew a 485 EAD, there's no fee involved. So yes, they can give everyone an EAD. The president has the power to do that through their executive authority, but they also, I hope, have learned some lessons about how to operate more efficiently and make sure they can handle these programs that they're trying to do. And so that's where my concern is, that USCIS might just say, no, we can't handle that volume. We can't handle that number of cases. We can't do those EADs and APs, without the fee. And of course, I know people would be willing to pay it, but they'd have to go through a regulatory process to change the fee structure, which they're already in the process of, but it won't be in effect for October. So that's just kind of my thoughts on it. Again, I would love to see their
I recall, Emily, that when Obama came in the presidential debate, he said he's going to pull out the troops from the Afghanistan. He couldn't. You know why? Because the general said, no, you can't do it. We can't pull this thing out for you. And we have this tough president. I mean, we may disagree on Trump on a lot of different things, but he's definitely a very tough guy compared to the other people. The generals in Afghanistan said, no, you can't do it. We can't do it. Now, when Biden administration came in, though, he came like, I am the president of this country. You are supposed to obey me. When I say walk out of Afghanistan, you are walking out of Afghanistan. So definitely, I think so. This guy can do it. Now, having said that, let's go back to 2007, though. That was the Bush administration. I recall how tough Bush was when he first came into administration. Though, the processing time for the 485 at that point of time was 4.5 years in Houston, and in most of the districts, it was almost like that. In Dallas, you take San Francisco, you take New York, a lot of those districts were. So when he came in, he said, reduce the time from 4 years to less. You know what the district directors did, Emily? They were sleeping. They didn't act on it. And 6 months, the processing time increased by 3 months. Instead of 4 years, it was 4 years and 3 months. You know what Bush administration did? He said, all the district directors are fired 6 months from now. In those 6 months, what happened, Emily, was the processing time came from 4.5 years to 3 months. We were begging them, don't approve the green card within 3 months, because when the family are living together, we need to prove that these family, the young couple that just got married, were living together. We can't find the documents enough. Just wait for 6 months before you give the green card. We begged the USCIS at that point of time. They brought the processing time down. I think so. This administration can and should do it. Will they do it? Is a question that we need to look into.
All right. So are there any other documents that people should prepare for besides the Supplement J? You said the birth certificate, marriage certificate for those that are filing as derivatives. Thankfully, we don't have to worry about that crazy 944 form and all those financial documents this time around.
That we did in 2020, yes.
Yeah. So other than that, you're looking at just your visa documents, all of your I-797 approvals. You've probably been gathering every 3 years your H1B petition. It's helpful to have a copy of your labor certification filing just so you can verify the dates of your employment that were listed previously. And as part of the 485, you do need to give your address history and your employment history for the last 5 years. So if you've moved around a lot or had a lot of different jobs, start thinking back and putting that list together. Those are probably the things that take the most time to gather.
Especially, Emily, I'm concerned about the employment history, though. I want everybody who's listening to this who thinks so that the priority date can move forward. They should think in ways where they need to prepare the 5 years employment history. Why is it very important, Emily, 5 years employment history? Sometimes it doesn't match with the H1B. Look into your H1B, look into your EAD, look into your documents to see if it's matching the 5 years employment history. They're going to ask this question: who is the employer? What's the address of the employer? From what time to what time you work for the employer? What is the title that you used for this employer? These are the things that they're going to ask for the past 5 years. So you have to make sure that if they're tallying with your H1B now, your H1B extension does not have to be approved. The transfer does not have to be approved, but it has to be filed within that period of time for you to be eligible for it. So please make sure that you prepare 5 years employment history, 5 years address history, keep it ready. Of course, as Emily has pointed out, the birth certificate, I-797s, passport, visa copies. Medical, you don't need it to file the 485 application. So if you have all these things, you'll be good enough to file the application. And of course, employer has to cooperate with giving you the 485J supplement, which is absolutely needed for you to file which is absolutely needed for you to file the 485 application. Anything else, Emily, before we go to the next topic?
No, we can go to the next topic. So what should someone do if their 6-year limit is about to be reached and their PERM is still pending and it looks like and the PERM was not filed more than 365 days ago? Are there options for someone to extend the H1B? Do they have to leave the country forever? What can they do?
Yes, this is coming very frequently, Emily, as it's taking a longer time to get the labor approved right now. Previously, people were thinking it's going to be approved in 6 months, which is not happening. So yeah, they can, if they have an H4 option, please go for the H4 option. It's easier. If not, though, you may want to consider if you can spend some extra time outside the country so that any time that you spend outside the country will be deducted from the 6-year time period, though. So if you can do that, that's going to be easier for you, where you can reclaim some 2 or 3 months when you spend outside the country. There are ways where you can go to Mexico and come back. If you go to Mexico and come back, you don't have a visa, you can still come back if you have the I-797 approval, as long as you're coming back within 30 days. You can do that multiple consecutive times. That's one thing that you can look into. You can look into B2 option to stay in the United States on a B2. And after you get your labor and I-140 approval, you can then convert into H1B. You can also consider going to your home country or to any other country and come back after the labor and I-140 is approved. What is more important for you is that when you are not employed with that company, will your employer proceed with the I-140 application? That is a $1 million question for you. If they are not going to do it, you are doomed. So that is, as long as your employer is willing to cooperate with you, the other steps of especially B2, H4, and going outside the country and coming back, they all can work for you. But if your employer is not cooperative, it's going to be a doomsday for you. So be prepared for that. Anything else, Emily, before we go to The last topic for today before we go to questions?
Nope, we can go on to advance parole. So if I have my H1B approval notice that's valid till 2025, but the visa's not stamped in my passport, I have my 485 pending, I received my EAD and AP combo card, and I travel and avoid visa stamping and come back on my AP, do I have to use my EAD now, or still am I in H1B status?
I know we both disagree on that. Now, here's the question. On the I-94, when they came into the United States, they were on the online I-94. It says that it's advance parole. It also tells that it's expiring in 1 year. You can ignore that. You're fine. You can stay in the United States because your adjustment of status is pending. And now the question is that, are you on a H1B? I say they are on H1B. Of course, I know you disagree with me on that. But this is the reason why I say they are an H1B, because they don't have to update their I-9 form with the EAD, even though they enter on advance parole. They can extend the H1B with this, they can extend without any problem. They can transfer the H1B from company A to company B. That's not a problem. They can file an amendment with that H1B. That's not a problem. They can use that H1B if their spouse is on, let's say, F1 or maybe H1 and they want to convert it to H4. They can use that H1B to extend, they transfer their spouse to H4 and probably EAD. Also, they can do that. Now, if, the principle what my old boss told me, Mr. Halim, when I was working with him is, if it looks like a duck, if it walks like a duck, if it quacks like a duck, it probably is a duck. Now, on that basis, if everything it says that it's H1B, it is H1B. Of course, I know you disagree with me on that. Go ahead, your version, Emily.
I think we basically have the same version. The only difference is the way that the policy memo is written suggests that you don't get back into H1B status until your next filing is actually approved. And they said in that memo that they would clarify that when they came out with the AC-21 regulations. 20 years later, they finally came out with the AC-21 regulations in 2017. And they forgot to clarify that part. So we don't really have any clarification on it. But the good news is nobody really cares. It doesn't make a difference whether you're on H1B or EAD because no one's asking that question. No one from immigration is going to ask you that. Your employer's not asking you that because they're not needing to update your I-9 form. So it doesn't really become an issue for anyone, as long as, to make sure that you are maintaining your H1B status, you need to work in the location that your petition is approved for, at the pay that your company is offering you under the terms and conditions, the job offer is the same and all of that. So as long as you're continuing under the same terms and conditions of the H1B, for all intents and purposes, you are in H1B status.
Anything else, Emily, before we go to the questions? And here is one question that's coming from Abby. I need your help on it and we need to discuss on it. Is your team going to start accepting the 485 applications? I had discussed with you, Emily, about it. We are considering that to accept the applications right now itself. But Emily, what do you say?
I mean, we definitely did it before in advance of where we thought the priority date would become current for people. I don't see any reason not to, as long as people are aware that we might prepare everything for nothing and not be able to file it, and we have no control over that, but I don't have a problem with it.
We're going to let you know in about 3 or 4 days, guys, and you can subscribe to our newsletter, and we will let you know about it, or how the terms are going to be when we accept the applications. One thing is important is that if you're already our client, of course, we already have all your information, you're good. If you're not our client, the main thing that you need from you is that, is your company going to be okay for us to file the 485 application? That's one thing. Second, we need the labor certification approval copy from your company. We need the I-140 approval copy from the company. And we need an assurance from your company that you are going to get the I-485J signed by your company. That's very important. We have some companies, the MNC companies that we work very closely with, even though we don't represent them in their labor and I-140, they allow us to file the 485 application. We don't want to name those, but I would just say that they are the two top companies from India that we work with and we file the 485 applications. If you belong to those two top companies, then we are fine to work with you. But if not, the 485J supplement is something that you need to obtain. You need to get it signed. We can prepare it for you. We need some basic information from you where we can get it from the labor certification. There may be some small information. So once you get that, yes, we would be accepting the applications from it. Emily, what if some of the guys, they have an I-140 approval with company A and they are working with company B? Can they go back to company A and get the 485J supplement with company A to file the 485 if the priority date becomes current?
Yeah, that was definitely the question of October 2020. And we said yes. I mean, as long as the whole 485 process, the whole green card process is on the basis of an offer of employment that you will take when you get your green card. It's not based on today's employment or actual employment. So as long as that old employer is willing to continue to offer you that job that they sponsored for you on the labor certification, and you're willing to take that job when you get your green card, yeah, they can proceed to file it. Of course, they do have to file, sign the supplement J. Some companies will tell you, no, you have to be working for us to do that, or you have to join us once you get your EAD, but that's a company rule, not an immigration rule. So from an immigration standpoint, there's no requirement that you be working for the company that sponsored you in order to file the 485, as long as the job offer remains available.
Question from YouTube is asking the question, should I do the premium processing when I am getting the I-140 with company B, porting the date from company A since the priority date is going to be current? I don't know whether I would spend that much money at this point of time for getting the premium processing approved for the I-140. The main reason is that, hey, even if you have the I-140 pending with company B, we can use the company A's I-140 approval, company B's receipt notice of the I-140 with a 485J supplement from company B. We can file your 485 absolutely, or your company can file a 485. It's not essential that you have I-140 approved to file the 485 application.
Sunita says, can the renewal of an H4 EAD be filed after the expiration date of the previous EAD? Yes, it's still considered a renewal, even if you're technically filing it late. So you don't have to maintain constant EAD approvals. But if you are filing late, you will not qualify for the automatic 540-day extension, or which is normally 180 days. So you have to have filed before it expires and have an already extended I-94. If you're filing after it expires, you have to stop working from the time your EAD had expired until you get the new one.
Question from Nitin. If the I-140 is pending for more than 180 days, 485 is pending for more than 180 days, I-140 is approved, and I have an EAD approved, do I need to submit any new documentation from the new employer for the EAD to use the EAD? The answer is yes and no. The new employer, if you have the EAD approval, you have an I-140 approval, it's been more than 180 days, you can move to a new company if the new company job is in the similar profession. Now, the new company may need to submit the I-485J supplement if there is an RFE, and if there is an interview, they need to submit the I-485J supplement. Now, if there is no RFP or if there is no interview for 485 application, it's optional. The company B, it's optional for them to submit the 485J supplement. Some of the companies will go and do an advanced submission of the 485J supplement. Some of the companies will say, no, we only do it when there's an RFE or if there is an interview. So that's optional though. We, from our office at this point of time, I'm recommending wait until there is an RFE, wait until there is an RFE, or wait until there is an interview to file the 485J supplement.
So he wants to know, can the sponsored PERM position be an unspecialized or non-technical in nature? And will that cause a specialty occupation RFE at the I-140 stage? So the PERM position does not have to be technical. It doesn't have to be an IT position, for example. And there is no specialty occupation part of the I-140. That's only for H1Bs. What the PERM position has to qualify for is either a unskilled worker, a skilled worker, a professional, or a professional with an advanced degree. Those are the different categories of EB1, 2, and 3. And so you've got to make sure that the position that the PERM is being filed for fits one of those categories, so you don't end up with an approved PERM and then a denied I-140. But there are unskilled positions that can be used to receive an EB3 I-140 approval.
Question from Nepal 123. My priority date is March 15, 2023. Do you recommend doing medical soon, or do I get the do I file the 48? Do I get to file the 485 in October of 2023? Most probably, you would be able to file the 485 application in October, since you belong to the rest of the world. Because when I see the priority date, it says May 1st of 2023. Yours is March 15, 2023. I'm assuming that your I-140s are already approved, because it most probably would have been a national interest waiver, because I don't see our EB1B or something like that. The reason is that the labor certification is taking a long time to get the approved. So definitely, if you have a labor and I-140 approved, you most probably would be able to file the 485 in October. That's my estimate for the rest of the world.
Sam says his H-1B extension was filed with USCIS and is still in process. He has a valid visa stamp till September 30th and wants to know if he can go to Canada for the weekend and come back, and will that have an impact on the pending application? So I generally recommend not to travel while an extension is pending. In your case, you're coming back based on the valid visa stamp. Your underlying petition has not expired yet. But the problem is, every time you enter the U.S., you're going to be given a different I-94 number. When your employer filed your H-1B extension, they gave USCIS your current I-94 number. USCIS does not update your I-94 number based on your travel when they issue that approval notice. So you're going to get an approval notice after you've traveled that actually has your old I-94 number on it. It's not a huge deal, but it can be a problem for driver's license renewals and other things like that. So I just would say avoid it, get the petition approved, or stay out until it is approved and then come back in. Otherwise, you might have to travel again in order to fix the I-94 issue.
Question, is it common for the companies to file the 485 application when the I-140 is approved when I'm working for the company, or do they actually tend not to file the 485 application though? 99% of the companies that we know, they do file the 485 application. If by any chance that company, after the 485 becomes current, they don't file the 485 application though, that company will cease to exist in 2 years. If it has immigrant employees, they're going to leave that company completely. We have noticed that in 2007, there was only one company that was a client of ours who refused to file the 485 application. That company just in 1 year disappeared from the face of the earth, because every employee of that company just left that company, because that's the worst thing that you can do to an employee. So we haven't seen that much bad behavior, except that one single company. We haven't seen it from anybody. No, we haven't seen it.
Sharada says, if I filed for my green card more than 180 days ago and I have the EAD, can I do a part-time job in addition to my job on the L1 visa? And can that part-time job be any job? So you can do a part-time job, but be aware that when you're using that EAD for that part-time job, you're no longer going to be considered an L1 status, because your L1 only authorizes you to work for the company that sponsored the L1. So you'll be out of L1 status. Now you're in adjustment of status, which is lawfully present. You can stay, you can work using your EAD, you can travel using your advance parole, but you do need to continue to have the job that supports your 485. That's the job, the EB1C managerial job at your company. Then you can do anything else on the side without impacting your ability to get the green card.
This question comes from Arun Ravirala. My H1B 6 years quota is done. I have H4 option. What are the chances of getting H4 in case I go to India for a short period of time? Can a male person get a H4 visa in India? That is one of the sexy, what do you call that? I'm sorry.
Yeah, sexist.
Yeah, that's a bad word that he used. But anyway, that's a question that he asked. No, I don't see any problem in you getting the H4 visa. Yes, male people in India can get the H4 visa. Look at me. I got the H4 visa. When I was going for H4 visa, Emily, I was being told by some people, oh, you're a male guy. You can't get a H4 visa. So that's what they do. Look, I looked into that definition. It says spouse. Until the time I came in, Emily, I don't know of any male guy who came on H4 visa. I don't know. I was the only guy that I know of at that point of time. But yes, Mr. Arun Ravirala, male guys can get the H4 visa. Absolutely not a problem. They will not discriminate. I guarantee you that.
Nitin says his spouse is on her own H1, but doesn't have the visa stamp, but she will be getting the EAD and AP based on his EB1 filing. And he wants to know if she travels and comes back to the U.S. on the AP, does she need to inform her employer or does she need to do anything to continue working on H1? So she does not need to inform her employer because her I-9 documentation was based on the H1B, which is not expiring. That's the only time the company is going to be asking for updated documents to prove her ability to work. So if her H1B is not expiring anytime in the near future, you don't have to inform anything of the company. She doesn't have to take any action as long as she comes back to work for the same company and the same job under all the same terms and conditions.
Vaibhav has a good question. Should the master's degree should be directly related to the H1B job profile to be qualified for the master's cap? I have relevant work experience in India. Can I still get the H1B? So, for example, if you have an MBA degree in finance, but you have a previous experience and education that qualifies you, let's say in computer science, can you use the MBA, which probably may not be directly related to software engineering? Can you use that MBA to get into the master's cap? Absolutely, you can. Absolutely, you can. No problem. It does not have to be related to the H1B job. It can be completely unrelated. Let's say you have an MA in arts in United States. And let's say you have a bachelor's degree in computer science and relevant experience in India in computer science. Can you get a H1B in computer science while you have an MA in master's in arts? Can you get into the master's cap because of the MA arts? Absolutely, you can. No problem with it.
David has his 485 filed 4 months ago, and the L1B extension needs to be filed. And he wants to know, once he hits 6 months, can he switch jobs instead of going for the L1B extension? So in order to qualify for AC21, your 485 needs to have been pending for 6 months. And then the new job that's being offered must be similar to the one that you were sponsored for. So you would meet that requirement. However, you need a way to actually work for that new employer because an L1 cannot be transferred from one company to another. So ultimately, it depends on whether you have your EAD issued based on your 485 yet. If you don't have the EAD, you have no way to change jobs, even though your 485 has been pending for 6 months.
Question with regards to, I'm outside the country, can I file the 485 application? No, you cannot. To file the 485 application, you have to be in United States. Of course, there's a different process called consular processing. That's a very lengthy process, though. That is a very lengthy process that you can do. It's called consular processing you can do. But for filing the 485, you have to be in the country. Emily, one thing, if they do, of course, there's always a question, if they do the dates move though, I'm estimating that they're going to do it a little bit slowly so that they can handle the issues much better. I think so. They made an attempt in 2015 in the Obama administration to move the dates. I don't know what happened to them. Who opposed it in September of 9th of 2015, though. They did move the dates a lot more aggressively, though. I don't know if their point at that point of time was practically to give an EAD, an advance parole, to all the people whose I-140 was approved, but they did move very aggressively, but they didn't make it current in 2015. That's my estimate. I mean, my advice to the USCIS is, and the State Department is, don't make all the dates current immediately, at least make a significant progress so that you can handle the work better. What do you estimate, though, that they will do it? I mean, what we want is different, though.
You're asking me what's my prediction of whether they will make the filing date current?
No, if they make the current, how do they do it? Will they make everything current, or will they go in installment basis?
I think they would go in installment basis. I feel like they hopefully have learned some lessons from these previous mass filings. I mean, October 2020, they didn't know what they were doing. They did not know what to expect. They were not prepared for that. So hopefully they've learned from that a little bit and would move the dates more slowly to make sure that they can handle the load.
Can I change the employer while the amendment of the H1B is pending? Absolutely, you can. The new company, of course, need to file a H1B, not a problem at all.
Ravi Kumar has a pending 485 and his EAD is valid for another year, and he wants to change jobs, but wants to know if the salary is relevant for AC-21. Can he change jobs even if he's taking a pay cut, basically? Yeah, you can do that. There is no salary requirement for AC-21. It just requires that the jobs be similar. The location can be different. The salary can be different. Even some of the job duties can be different. It just needs to be a similar occupation. So I've not seen them take into account a major salary difference.
Karthik is asking the question. He has been laid off and 60 days is about to get over, but he has an I-94 until March of 2024. Can he stay beyond 60 days up to 180 days to find a new job? No, we recommend that you don't. It's considered a violation of status. It's considered out of status. And it has some negative consequences when you go for the stamping at a later date when you want to get the things done. So we recommend that you file a B2 application if you are coming very near to the 60 days of the grace period. Don't violate the status in the United States. It has a lot of negative implications at a later date. Try to comply with it. Sridhar Budati has this question. Do I need to inform the USCIS? Well, I moved from H1B to adjustment of status. My wife is an EAD 485 pending. No, you don't have to inform the USCIS when you move from the H1B to EAD. You don't have to. You don't have to. Now, when you have to give the EAD approval to the new employer, or if your H1B is expiring to the employer that you are already working, you just need to give them the EAD and they will update the I-9. That's all need to be done. You don't have to write to the USCIS. You don't have to inform the USCIS that you are now moved into EAD. You don't have to.
Blue says, is there any limit on how many days one can be physically outside the U.S. while working on an L1 visa? So technically, when you're outside the U.S., you're not on an L1 visa or on any kind of visa because you're not in the United States. So when you're working outside the U.S., you're not required to comply with U.S. immigration laws. You need to comply with the laws of the country that you're in. So there is no limit because you're not in L1 status. But anytime that you do spend outside the U.S. while you have that L1. You can recapture later and add it on to your 5 or 7 year limit to get that time back. Anshuman wants to know, can I extend my L2 I-94 by updating with my spouse's latest approval by going to Mexico? Yes, so we call that using automatic visa revalidation. This is assuming that your current L2 has not yet expired. Then you could travel to Mexico, and when you come back, you can show your L2 visa stamp as well as your spouse's L1 extension with the new I-94, and CBP officers usually will give you the new I-94 to the same date as your spouse's L1 extension. But you have to be very careful. You're not going there for the purpose of extending your I-94. You're not trying to extend your L2 by going there. So don't confuse the officer by handing over all of your documents and saying, I'm here to extend my I-94. That's not going to work. So you travel, you have a margarita, you stay at a nice resort, and when you come back in, you show your passport and your spouse's L1 approval, and the officer will give the I-94 to match that new end date.
Viros is asking the question, why don't you tell me the success story of you becoming an immigration lawyer and share your experience in USA? I don't think so. I have a successful story at all. When I got the green card, the priority date was current. The next month that I got the green card, and by the time I was already an immigration lawyer, the priority date went back. That was in June of 1996. On May of 1996, I got my green card. In June of 1996, the priority date went back. Right now, the priority date is backlogged significantly back, and people are waiting in line. So I'm not successful as an immigration lawyer. However, if the priority date becomes current right now, I will claim that I'm a very successful lawyer. Now, to do that, I request all the people to write letters to the administration to make the priority date current. We have put a draft in the link for you here. We expect everybody who wants their date to be current to write letters to the Secretary of the State and also the USCIS Secretary. The address has been provided there. Unfortunately, when you send the email, it doesn't go through. You have to mail you have to put in the physical mail. Now, when you send to the State Department, you have to send it to the address is fully given. When it's sent to the USCIS, there is it's just a zip code and there is a 4-digit code. You just need to use that. It will go. Please, we expect everybody who wants the date to be current to write the letters to the administration. When all the dates will become current, I feel that I'm a successful immigration lawyer. Now I'm not, with the priority date getting backlogged. 1 million people are so waiting in line. I'm not a successful lawyer. I'll be successful if you all write the letters and make the dates current.
Matthew says, in case the dates become current for the birth certificate, is it okay to have just a copy, or do we need the original for filing the 485? You just need a copy of it. The only time you need the original is if you're called in for an interview. Sometimes the officer likes to see the original and verify that it matches the copy. Dheeraj also said, I'm outside the U.S. with an approved I-140. Can I find some way to file the 485 application because I'm still employed with the same employer outside the U.S.? No, you can only file the 485 if you are physically present in the U.S. in a non-immigrant status. That being said, if the employer is still supporting the application, you can consular process and still get the green card. So if your I-140 was filed for consular processing, you don't need to take any action. It will automatically be sent to the National Visa Center for you to start that process and fill out the DS-260 application, pay some fees, and gather all of your civil documents and submit those. But if your I-140 didn't specify consular processing, your employer needs to file an I-824 application with USCIS to have them notify the NVC that your I-140 has been approved and you are now planning to consular process. And that can take several months. So if you're planning to do that, you should file that soon. And one more question was there. Previous employers I-140 was done by a successor in interest. And what happens if my spouse is outside the country? Can we still apply for the 485? So if there's a successor in interest situation, the new employer has to file an I-140 amendment. So you can file that concurrently, though, with the 485. So there is a way to still proceed with that. But if your spouse is outside the country, the spouse cannot file with you. You would file yourself, and then the spouse has to either find a way to get into the U.S. on a non-immigrant status and then file, only if the date remains current, though. Otherwise, the spouse would do what's called a follow to join process, which also requires that I-824 application.
Yogita is asking, does sending the letters, does it really help? I believe it does help. It does help. If you recall, though, when 60,000 green cards were being wasted in the financial year of in the USCIS year of 2021, which starts on October 1st of 2020, 60,000 green cards were wasted. But next year, though, the way they were going, they were wasting about 90,000 green cards were going in the trash can. You guys, more than 90,000 green cards were going in trash can. You guys wrote letters, made a big noise, made a lot of complaints. That's the reason why none of them went to waste the next year. Had we been very alert, in the first year we would have been fine. At the first estimate, we thought everything will be used, but later on we found that the USCIS deceived us. But the next year you were able to write the letters and were able to get it. The State Department acted very good. The USCIS acted very good. Nothing came waste. The complaint that we have with the employment-based green card, with Emily says, is that you guys are very comfortable making a lot of money, so you don't complain, you don't cry. Look at the people who are undocumented. They get a lot of voices, though. They get the Congress, they get the administration to work for them. The administration tried to give employment authorization to the people who have family waiting for a long period of time. There have been some court challenges for those things, but they try to give employment authorization to all the people who are waiting for family. Not all the people, but some of the South American countries. When it comes to the Indian nationals who have been waiting for such a long period of time, you guys don't write letters. You don't complain. You're very luxurious for leaving. That's fine. You're paying very good taxes. We're proud of you, but you need to let your voice know. You need to let your voice know to the administration. You need to let your voice know to the congressmen so that they can understand it. Now, don't look into whether your congressman is a Republican Party or a Democratic Party. Don't look into if he's favorable for the immigration or not. Write the letters to the congressman. You need to tell your story to the congressman. They need to understand. You don't have to be the author to write a letter to the congressman. You don't have to be the author to explain yourself, explain your struggles to the administration or to the congressman. And we have provided the draft for you to provide it. We said that family members should not be counted. You should write that letter too. You should also say that all the priority dates should become current. Try to make the campaign for it. We have given the drafts. We have given the addresses. We have given the resources where you can go ahead and send those things. Please use our services, use our links so that you can request the administration to get the green card faster for you guys. Yes, it works.
Eddie Oye says, I'm on STEM OPT. My wife is on OPT, and I have an EB2 NIW I-140 approval with a March 2023 priority date. Can we file for the GC EAD when we file for the 485? So I'm assuming your date is going to be current or is already current. And so you're filing the 485, yes. Anyone who's filing an employment-based 485 can include an application for an EAD as well as an advance parole, even though you both already have EADs, even though you're in F1 status. So yes, you can still file for those and get them. You should also include I-131 applications for advance parole, because once your 485 is filed, you won't be able to travel on your F1s anymore. You'll need to wait until you get the advance parole in order to travel without impacting your 485.
Ravi Kumar is asking the question from YouTube. Is the family-based spillover expected in the fiscal year of 2024? very unlikely. And if there is any, it will be very, very, very little, because there is no COVID and the consulates are more functional right now as compared to what it was in 2020 and 2021.
Srini says, have there been any successful I-485 filings for a child who's applying based on the revised CISPA guidance retroactively? So this is the change that happened to the Child Status Protection Act earlier this year, where the Biden administration said we can go by the filing date chart instead of the final action date chart. One of my cases, I did file a motion to reopen because it had already been denied due to aging out. My motion was instantly denied because it was more than 30 days denial, obviously, because I couldn't have possibly filed it earlier. Filed a motion to reopen again, got the ombudsman involved. They did eventually reopen the 485. So now the case is pending. And now they say that they're going to call her in for an interview. Why are they calling in the child of a employment-based applicant for an interview? I don't know, but at least the case is reopening, and hopefully we'll have a good outcome soon.
PB413, can the extension of H1B, H4 and EAD be applied in premium processing? If so, will the H4 and EAD be approved along with the H1B? The answer is yes, you can file it together. The answer is yes, they will adjudicate the H1 and H4 and H4 EAD together.
Bharat says he's in his 6th year of H1B, lost his job, and the grace period is there until the end of August. He's got the approved I-140, and his potential employer is telling him his I-129, which is the H1B transfer, will only get approved without an I-94, so he has to exit the U.S. to start working. Is this true? No, it's not true. The employer can file as long as it's filed before the end of the 60-day grace period. They can file an H-1B transfer, use your approved I-140 to get 3 years, and they can get it with the I-94. We do that all the time. I'm not quite sure why they're saying that. Maybe they're not aware of the grace period. I've come across a few employers who were aware of the grace period but just didn't want to mess with it, so they only filed in consular processing, which I thought was quite ridiculous. As you're forcing someone to travel needlessly, someone has to get the visa stamp and can't get an appointment. They're just delaying the ability of this person to be able to join their company. So yeah, that you would not need to exit as long as they file it as a transfer.
Kayati has F2B I-130 approved. Her priority date is not current. While the priority date is not current, can she file the EAD in advance parole? No, not at this point of time. They tried to make that you could get an advance parole if you belong to certain Central American countries, especially if you're from India. Definitely that choice is not there. No, unfortunately, you cannot file for EAD in advance parole right now. Maybe they will change their opinion though, but as far as now, you cannot file the EAD in advance parole until the priority date becomes current.
Rajiv says, this is an overlap of a short duration. Okay, if you have 2 H-1B jobs because you need to serve the notice period of one job while you're leaving and then start working for the new job. Are there negative consequences? It's not okay to have that overlap. The only way to do an overlap is if the H-1Bs were filed for concurrent processing. But once you've gotten your transfer, if you've started working for the new company, you have to stop working for the old company. You can't work for both at the same time.
Sam from YouTube has this question. What happens if you leave the employer within 2 months after you file the 485? Well, there is always a chance your 485 can be denied. But of course, I would strongly recommend that you contact a lawyer, because even though you left the employment, maybe the companies may still have a job offer for you. Since they haven't withdrawn the I-140 approval for you, we can consider that the job offer still existed at that point of time. But definitely, I want you to take the help of a lawyer. And even if there is a 485 interview for you, or if there is an RFE for you, definitely have a lawyer respond to it, because they may ask that question, why did you leave within 2 months after the 485? It's not a clear thing. It's a gray area whether you should get a green card or whether your green card will be denied. But I would recommend, if you first, don't leave within 6 months. And if you have to leave the job or you've been terminated, I would recommend that you contact a lawyer. There are ways around you can still get the green card. Anything else?
She says, can we travel on AP after changing employers? We also have the H1B stamp till the end of next year. So assuming that you have a 485 that's been pending for more than 180 days, and you've either filed an H1B transfer or used your EAD to join the new employer, and the new job qualifies for AC-21, meaning it's similar to the job that you were originally sponsored for, you can use your AP. It's valid regardless of which company you're working for. No issues there at all.
Anything else, Emily?
I guess we're out of time for today. Thank you all for joining us. Don't forget to subscribe to our newsletter by going to rnlawgroup.com. And if you're not currently subscribed to our YouTube channel, please go ahead and do that now, because we do from time to time do other live videos whenever any big news or updates happen. So that way you'll get notified whenever we're about to go live.
And if you want to make an appointment with me, Emily, or any of our colleagues, you can go to RN Law Group. Our schedule is available. You can block a time that suits you to speak with us personally. Wish you best of luck.